And rather than the doom and gloom that a lot of this seems to follow, I've tried to separate it into some of the new issues that are there and how to react and how to deal with it. And I welcome any comments or suggestions to help us gain some control. I think we've lost, but at least some way to help with what's going on in the healthcare and certainly plastic surgery. No relevant disclosures for this talk, so I can't begin without mentioning the Affordable Care Act and how this may impact plastic surgeons. And a lot of this is based on reading the act and looking how it may continue. No matter what happens politically, this act will stay in place in some level. And it is wise to expect there will be changes in reimbursement, there will be coverage and management direction changes, and along with that, clearly increased liability. Some think that this whole act has been a huge lob to the trial lawyers, as you'll hear a little bit more about. For those of us who lament who moved my cheese, there's going to be a lot of cheese moving, as well as potentially a huge opportunity that I'll get to. So what is the Affordable Care Act and how does it impact us? Well, at first there'll be a large volume, maybe not as large as was initially anticipated, but clearly there will be some overload to the system. In Texas, there are a number of physicians who are withdrawing from Medicare and Medicaid, but regardless, there will be more than anticipated into the system. Everything we're hearing will show reimbursements dropping. A lot of our established care patterns have no liability protection. Now we can order a number of tests and practice, as has been called, defensively, just to help protect ourselves. That, I think, will be not allowed as this evolves and progresses. I also, and this is just my opinion, I don't believe that a physician will be able to opt out if it continues to go with the controls it has now. Some states, Massachusetts, you want your license renewed, you will do Medicare, Medicaid within that state. They're never going to get the number of physicians to handle the volume of patients unless they make it mandatory. So I would anticipate that that will progress in that direction. The added costs are going to be to hire someone to either triage or interact, PA, RN, added staff. The required electronic medical records will add to liability, and I'll get more into that. Satisfaction, all that has evolved and continuing to change sets up liability. Some of the language in EMR may protect liability, but a lot of us anticipate delays in treatment, delays in diagnosis. The EMR changes, we're already seeing a lack of personal contact with a patient. And we're already hearing complaints, the head's in a laptop, a notebook, you're not really interacting. So one of the recommendations as we evolve in this, as specialists, and certainly the primary care people are realizing this, say hi, have your interactions, don't stick your head in a computer and initially do that. And I would apologize to the patient, I'm sorry I have to enter this and do this, and try and get a balance with preserving some personal contact so you can interact at a better setup. Some of the EMR default answers, and I'm involved in my facility, we're using Epic, trying to set up smart texts and avoid some of the pitfalls. So you run through a history and a physical and you're checking boxes. The minute you check something that may or may not be true, you're setting up liability for yourself. So I'd be really careful and spend time looking at what are the plastic surgical standard texts, what are the plastic surgical op notes, how are you doing op notes, are you able to dictate it, are you able to have standard op notes that you just drop in place? If so, in discovery in a lawsuit, well, doctor, every one of your op notes is the same. How can you individualize care? So it both protects us a little bit and I think has a great potential for setting up a lot more of problems in caring for patients. If you do reviews such as I do, I get a DVD of data, and it is so difficult to sort through and evaluate. So if we're in a reconstructive mode and we're looking at difficult patients who are sent and they have EMRs up to that point, my God, you're going to get a book, and how do you decipher through with what's really important and what's not? It is what it is, and I would anticipate that that's going to have some concerns. So work with it. More bad news in the Act is choice, both patient and doctor. HHS determines what panels and treatment courses. It may no longer be what best practices would recommend or even what you think is appropriate. Many believe that physician autonomy will become a thing of the past. There has to be rationing of care of some level, but specifically no liability protection at all. And the preferences from everything you can read seem to indicate ages 15 to 40. Well, I'm screwed. I'm on the other end of that equation. And it is what it is. Again, expect that there will be some issues and problems. There was an interesting article trying to redefine a physician's ethical obligations, that maybe there's not the ethical obligation to provide a level of care. Maybe the ethical obligation is to comply with what HHS or a panel dictates is what is reasonable care in terms of what the Act may dictate from a responsible financial doctrine. Well, and there's no liability protection for those determinations. So there will be comparative effectiveness research, and I'm not sure many others will be able to tell you it's going to be evidence-based data. Everything we're reading is it's not evidence confirmed. It's going to be dictated by a committee and levels of care. So if you look at paper performance, and I'm painting a bleak picture, but I think the more you get a feel of what the negatives are, the more it might be easier to look at where things are. There's an independent payment advisory board, 15 non-elected bureaucrats with the goal of reducing per capita spending. Well, that's going to come at the physician cost, either by reducing reimbursements, by defining what will be included and what will not, and the paper performance will be following guidelines. So here, if you have a guideline that ethically you have an issue with, if you don't follow it, you may be penalized financially as a result of that. Not a very comfortable environment. You'll have triage for care because there's no way you can see all the people that seemingly now are being directed not to keep your own physician, but to be in some of the panels where there will be a lot of patients. If there's a delay in diagnosis, if there's an issue, you're still liable for that. And the Act itself prohibits any explanations or defense as a result. So one ought to anticipate and be really careful about that. Well, the impact is going to be a high volume of patients. I'm seeing, in doing a lot of reviews, an increase in unreasonable expectations. I think many of us may be seeing this already just in an aesthetic practice, but even in a reconstructive practice. As I've said, no liability protections from delays, misdiagnosis, treatment denials, any of what the system, the bureaucrat, or the Act may dictate is now appropriate medicine. And that becomes a real issue. The head and laptop, I would be cautious about that, figure out ways to function. The rationing, look at how you can work staff as a very viable team. and set very good patterns for triage, established what do you do, patient comes in with this, what are our methods of treatment, what can you do, and I would follow that pattern as far as you can. Privacy issues are going to be there as well. There's a big concern about a lot of the patient safety organizations from a peer review establishment. Right now they're privileged, and if there's a lawsuit, they're non-discoverable. There's a real concern whether the safety organization that will be able to talk within a network and do quality assessments will be peer protected. I'm not sure that that's there. So make sure your business agreements as part of HIPAA is very up to date and very complete with anyone who may have access within your network. We are already beginning to see encore physicians enter into the aesthetic market, and I would anticipate more and more. I'm an investigator for a state board, and I'm looking at all sorts of specialties as cosmetic surgeons, and let the buyer beware. I don't see that lessening. I see it increasing, and I would be cautious about how we respond to that. It's not a turf issue. It's a patient safety and value issue. And the protocols for triage, you're going to be responsible anyway. You might as well set up as much as you can and elaboratively as you can what to do, who needs to be seen, put some responsibility back on the patient who elected to be in this system to start with, and that may be one of the saving graces to get through a lot of this. What's the opportunity? I'm painting a very bleak picture. And someone sent me this little caption up in the right, how to get men to wash their hands in a restroom. Well, I wouldn't go that far, but if you're in a network, this may be an opportunity to set up a level of care different from the Affordable Care Act. When I was in Britain in the 70s, and this is where we're seemingly headed, yes, you could wait in the system, and I operated on patients who were waiting 4, 8, sometimes over 10 years, or I can operate on you next Tuesday, and we'll hire a hospital, an anesthetist, a nurse, and recovery, and I think we will see more of a tiered system. I don't see any way around that. And it may be a unique opportunity to have data. Data will rule. The Kaiser group has a unique opportunity with a very large volume to maybe even set some trends, and instead of allowing HHS to determine what should be done, if there is good data showing effectiveness and patient safety and some sharing of costs, that may help dictate where things are. So make sure the EMR doesn't hurt. Expect everything that will happen with this Affordable Care Act, time of being seen in the office, the duration of visits, all of that in an EMR system may be placed. Look at instructions, look at follow-up, put some of the onus back on the patient, and that may be able to help get through it. A leading source of all issues today is failed expectations, the most common cause of lawsuits. I'm seeing it increasing even in states with tort reform, which is unsettling. Patients expect a perfect result, and that's really frustrating. If you explain a complication in a consent document and it's very elaborate and they happen to get it in the past, God, weren't you smart? You thought that this might happen to me. Help me get through it. Now, what did you do wrong? Well, wait a minute. It's listed in the consent. Oh, I know, but you must have done something wrong in order for that to happen. That's the mindset. And I'm not sure how we avoid that. The more the patient comes in and demands a procedure, the more we acquiesce, the more there's an issue. Never events, whoever termed that didn't do anybody any favors. There's hardly a never. All of a sudden, that's now negligent. I wrote about the Babe Ruth syndrome, who led in home runs but also led in strikeouts. So there can be a real issue if you're required to hit a home run every time you're up at a plate. You're going to strike out a lot. Every strikeout potentially is a lawsuit. So I'd be really cautious. On the one hand, I'm painting an economic change where reimbursements may drop, aesthetically as well, just from significant competitions within and without plastic surgery. The managed care world will show similar issues. Be careful not to accept every patient who comes to see you. See them more than once. Be careful of not creating a warranty, and that may help a little bit. This dilemma is confusing. Overheads going up, discretionary income, which manages a lot, is changing with taxes and income changes, more unreasonable patients with health issues. I'm seeing more and more patients who've had a stent. Well, what type of stent? Oh, some cardiologist did it. Well, were you taking a pill? Well, I was, but I couldn't afford it and I stopped. Well, can I get the type of stent? No, that doctor moved, I moved, and here you are wanting the patient wants a procedure, and that dynamic can be a real issue. Faulty expectations, hopefully we're not creating by a false image to get the patient to sign up. Have to be really honest in the informed consent as to what's your experience, what are the risks, hazards, what are alternatives. A lot of the aesthetic world they don't need, they want, and you ought to try and get it as perfect, and I hate to use that word because nothing ever is, as possible. So what are the issues that I'm hearing about, whether it's Affordable Care Act or not? This is not going away. There's not a week goes by that I don't hear some complaint about reputation, HIPAA, social media, and a lot of these. So we're going to go through them and kind of have a little fun, and these are kind of cases that I hear. So Plastic Surgery Anywhere notices a patient complaint in social media about the practice. Care provided, everything's negative. It's so specific. You look at the date that it's posted, and you look at what the gist of the complaint is, and nobody that you saw fits that at all. And I love reps because they travel around office to office, and that's a great way to know gossip. And here one of the reps says that, yeah, a competitor employee was saying they posted it, and you really don't have proof of that. What do? I'm hearing more and more of this. Well, there's an IP address if the web site can do it. And if the IP address is in fact another plastic surgeon's office and site, I think that's an ethical violation, at least one and more. And I would file a complaint, I would hire an attorney, and I would send a cease and desist to the other practice and make it very known. So let me say on the flip side of this, now you have the most wonderful, happiest patient you've ever had in your practice. And the patient says, I'd love to say a wonderful thing about you. Can I just post this? I'm on Yelp, I'm on Real Self, any of the media sites. Don't post it from your office. You can give them any of the sites to go home on their IP address, because there will be a perception if it's posted from your office that in fact there's an issue and it's not real and it's fraudulent. So here's a search that shows inundated with negative comments from a patient who had a breast reconstruction. Look what she did to me. Photographs of the patient's abdomen and in a bra, hurting referrals, business. Patient was incredibly non-compliant, missed many visits, all sorts of suspicions, and now she wants money to stop it. I hear this a lot. So what do? Well, I'm not one to suggest complying with extortion. So I have lots of issues about whether you ought to engage this or not. One, there ought to be a consent for use of email and other forms of communication. I'll show you an example in the new consents. Save and incorporate everything into the medical record. There's not a medical record I review today that doesn't have emails attached to it. Have an office guideline for what can be said and what you respond to in an email. I think that's important. Make sure the emails and the data is on a protected computer and they're not open to theft and security issues. And I would check your web constantly, whether you use Google Alert or any other component. Know what's being said about you. I think that's important. This is this communication acknowledgement consent. And I'm not sure how well it shows on a screen, but I think the first time the patient is in, and certainly frequently when they come back in, how may I contact you? Telephone, home, work, what's your cell phone? Can you text? Social media, pager, emails, regular mail. Make sure this is updated so you don't get a complaint, well, I never gave you permission to contact me. I think that's a concern. The negative blogger, a lot of stories, a lot of well-known docs have been significantly hurt. So here's a septorhinoplasty. Results are good. The patient doesn't like it. Many appointments, many issues of patient noncompliance, cocaine use admitted to, not documented. You really can't say anything, but here's this blog. What do you do? And now here's an extortion demand in order to stop it. Well, one, you have no assurance that once it is stopped or paid that the blogs will change. Often they do not, and that becomes a real issue. So there may be some help as to what to do. So if you have somebody in a blog, an email, some other form on a site, you really cannot comment back. HIPAA doesn't allow you to do that. You have to be incredibly careful. Any internet communication exposes the practice to not only negligence but regulatory issues, as I'll get into. I'm hearing more that both competitors and reputation companies. So you have an appointment from a reputation helping company on Thursday, and then lo and behold, Tuesday there's a negative complaint about you. God, Doc, we got you just in time. We're going to be able to help you. Well, how do you know that they didn't post it? And I'm kind of hearing more and more that it's just a little bit too suspicious, and that may be a part of it. I love the tweeters about what happened during the case and where things are. Well, who's operating? Or if the tweeter is not the surgeon, or you misrepresenting yourself as the surgeon. So patients have the right to their opinion. Shouldn't be defamatory. And something negative is not defamatory. Shouldn't misrepresent, shouldn't confuse the public. If we have time, we can get into that a little bit. So I think it's worthwhile, since a lot of the issues that come up have to do with office policy. How long am I waiting? Do I pay for parking? What are the office financial issues? Do you have a policy on smoking? Issues, aspirin noncompliance. And I think it's kind of wise, if you don't have a blog, maybe to establish one. Don't pick the patient's name. Don't even pick the same procedures. Just have a fictitious, here's what can happen if you're non-compliant. Here's what can happen if you fail to follow up. Here's what can happen if you smoke, or whatever else you want to pick. And you hope that the brighter reviewer or reader of these reviews might suspect that, well, maybe this negative review didn't actually follow protocols. Maybe they really didn't understand what's going on. Always the best advice is matching patient selection to the procedure and have the informed consent represent that. I don't think there's a lot of recourse. Everyone wants to know, what can societies do? I don't think they really can do much at all. Some of your malpractice can cover liabilities, but only if it's negligence related. And you really cannot sue to block opinions. Some suggest that if you do, and I'll talk about anti-SLAPP in a minute, you expose yourself even more. I won't get into medical justice. There's an argument by an ethicist at Baylor who thinks it's unethical to stifle speech because you're actually controlling the content, both good and bad, and Yelp won't follow it anyway. So that still remains to be seen. I like the people who run it. I think their heart is good, but I'm not sure that that will function completely. Grant Stevens is a great method as long as it's legal in your state. So if you have a great result, as I'm sure everybody gets, and you have a patient and family who says, this has been the best experience to me. All right, unsolicited, well, I really appreciate that. Would you mind repeating that? Could you go ahead, if I give you an address to log in from your home computer, would you mind saying that? So you can get your champions, your folks that will come out from the woodwork and say nice things. And many experts in social media believe that the more you have a negative review among many positive reviews, it's certainly more believable and feasible than 100% positive reviews with a suspicion that your own office posted them and there's other concerns. Anti-SLAPP is increasing, and many believe it's in 27 states. It'll be federal and in every state. It's a strategic lawsuit against public participation. So I have the right to voice an opinion. Yet if I voice that opinion, I'm sued by the one the opinion's against, and I have to defend myself, which can be prohibitively expensive, and I just acquiesce. Well, this law says, in fact, the suit must be dismissed, and in fact, my legal fees get paid for. So this helps the patient. If we sue them, it may help us if anybody has a lifestyle lift issue where they, in the past, have been very strong to challenge your opinion against them. This may be able to help that because it really does deal with public participation. That may go away. So here's Jane. Poor Jane is a blepharoplasty. Doesn't like the result. She still has some upper lid fullness, paid by a credit card, and now seeks a chargeback for everything, the office, your fee, OR, and anesthesia. And the credit card company asks you for a reason why they shouldn't just take their money back. And there's an argument whether HIPAA actually prohibits you or not if they pay for the service. There are some who believe that you're allowed to respond, here's a procedure, yes, it was done, I have a consent, the procedure was done, and therefore they're not entitled to a chargeback. I'm not sure if that is there, but it's arguable. I'd rather have a consent that looks like this, and this is in the new consents, that once you pay by credit card, debit card, or even financing, you waive your HIPAA right that if you challenge this, then I can actually respond. And I think that this may be a way of helping what I wrote about as a credit card scam. People pay by credit card and then challenge it knowingly afterwards to get the money refunded to them. People continue to find ways to do things. So here's Janice now seeks a consultation for eyelid aging, mild ptosis. You both agree it's a cosmetic, non-functional problem. She has a cosmetic blepharoplasty, doing well, paying all parties. And then she files insurance, and lo and behold, they accept it. And even worse, you're on the panel. Now, by contract, you have to refund the money and accept whatever amount, pennies that they pay. So I think we may see more of these quasi-covered procedures. As Affordable Care Act continues, this will go away probably. So here's another cosmetic surgery financial agreement. For me, if I knowingly bill insurance for a cosmetic case, I think that's fraud. So I've used this for years now. Patient understands you want me to take care of you. It's cosmetic. I'm not going to accept assignment. It's irrevocable. You can't change your mind later. It would be fraudulent to me to submit a bill, and it's there and it's done. And I think I would incorporate something in some of the quasi cases, nose, eye, abdominal cases where that may hold. Here's this same practice, and now they get a lawsuit from breach of privacy. And I'm hearing more and more about photographs. So here's Mary. Poor Mary now had a breast reconstruction, was so successful, looked great, that the practice wanted to use before and after pictures in their website. So Mary signed a HIPAA commercial agreement, only she didn't initial, she actually crossed out the commercial area in the website. And lo and behold, your team didn't check all this and never gave permission, and now it's used, and she wants a huge amount of money for her commercial use of property. Well, what do? And this has happened a lot. Well, on the one hand, you would hope that 8,000 people looked at the website. In reality, the webmaster can tell you exactly how many prospective patients or people looked at the website and looked at her picture. And if it's a few, well, you can negotiate that $50,000. You're going to have to pay something because you did violate her privacy, but it may not be a carte blanche check. It may be with some evidence showing that it's significantly less than that. Let's pick the same scenario, and now you have the picture, and Mary gave permission to use it. And I'm hearing more and more about this. So you have your file name stored in some system, and you change the name post-op breast reconstruction, but there's no scrubber of the metadata embedded in the file, embedded in the picture. So now you have somebody harassing poor Mary, and they have a mouse over the picture, and her name pops up over the photo. Real cases. Well, that's an issue. So in the consent, much like banks will do now, about protecting your privacy and security, you'll do the best of your ability. If there's a service that handles your website, make sure that they scrub everything. Make sure that the metadata is taken out, and it's a lot safer to proceed. But if there is a breach, we'll let you know. We'll remedy it as quickly as possible. Along the same path, here's the same practice as tweeting about a procedure. No names. Say you're not mentioning anything other than a woman comes in for X procedure and she's done well and it's a newer type and we're using some magic device or implant and here we are. Well, say the patient's friends know that she's seeing you. Well, you've just told everybody exactly what she had done. And in fact, it becomes really, really difficult to protect the patient's HIPAA rights. So law firms have done this where a lot of the criminal defense firms would tweet or talk about one of the cases they're handling. Well, you can't do that even though you leave names out. You can look in the docket and you can see what criminal cases are there, and you can know who's being represented by whom, and therefore you know exactly what's going on. Same issues. And the other part of this, be careful. If you're tweeting during a procedure, somebody is, and you're getting any issues of false expectations or a real complication, the plaintiff's lawyer is going to have a field day with what's more important to you. You're marketing your practice or, in fact, trying to take care of the patient. And that becomes really difficult to defend. So here's Dr. Jane Q. Public answering many questions, social media, in hundreds of the sites that are out there that we seem to be flocking to. So there is a Julie from an adjoining state asks about a lesion on her face in front of the ear. She's interested in a facelift, and in fact, when I come in to see you, she writes, is it possible for you to take this lesion off at the same time? So Dr. Jane writes, sure, very possible. Call for an appointment, come in. Julie waits 3 months, finally sees her PCP in a derm, who now biopsies a malignant melanoma that's been there for 3 months. Well, bad outcome, worse bad, because now there's a state board complaint. If you give advice, and I'll get on this more in a second, if you give any advice that the patient relies on, you're practicing in that state. That's a felony in some states. And even though you never saw Julie, you gave her information which in fact turned out to be negligent and was a delay in treatment. It may be hard to show it had a negative effect, but here you are caught in a really bad pattern. Don't practice in another state. We're all trying to look for prospective patients. Have two sets of answers. Have a general, nonspecific answer. Go see your doctor, check things out. There are a lot of ways to treat this. Once they're your patient, you can give specific advice. It's not an issue. All of these answers, copy and make sure that you can keep it as part of a record. Good habit, free legal advice. If somebody says something, one of your patients, in an email and it's incorrect, correct it. Not fighting, but thank you for your email on such and such date. Let me correct some of the misstatements there. Thank you. Have a nice night. Otherwise, it may be deemed implied and accepted by you because you're not challenging it. So let's get into some of the patient issues that are real today. There are a lot of non-compliant patients. What do? At some point, one has to say, you know, I can no longer be responsible for your outcome. Here's where we need to do. If you're not going to play nicely, I'm done. I just can't do it anymore. Let me get you some names and maybe you can find someone you can work with a little bit better. Be careful. Set goals, set expectations. Here you have a super hypercritical patient for a deep flap, 14 months post-op, and she thinks she should have a better result. Well, you already said once you'd revise it, and you did that 9 months out. She looks great, still emotionally depressed about her cancer and the reconstruction. Her spouse left, and here you are in the middle, and she wants continued tweaking. Insurance may or may not cover it, but it doesn't matter. It's still you. Well, what do you do with this? Well, set a goal, know when to stop. Very easy to say from me on a phone in a webinar. It's really difficult sometimes, but I see more problems going down that path. Well, just a little more. Let me just try this. Let me just try that. And then, in fact, you've made more of an issue where you may have stepped back. Get a second opinion. Make sure your staff's on the same page. Talk to one of your friends and tell the patient, you know, I'm not sure I can offer any more. I'm going to pay for you to see this other doc. Hopefully the other doc won't charge you, and try and work out something from there. I'm done. The other part that I use when I see a new patient, and there's no way I'm going to be able to satisfy that. I tried to explain it defensively. I never got anywhere. So I started saying, you know, I'm not skilled enough to give you the result that you're seeking. That was great, because would you go to a doc who just told you that I'm not skilled enough? Actually, two of my biggest referrers are from patients I never operated on. I'm not skilled enough. They went to somebody else. They got a very nice result that they were never happy with. So I'd be really careful about how you handle the hypercritical patient. If you pick it up in the beginning, great. If you don't, be really careful. Know when to stop. Here's Steve, former patient. He's a damn lawyer, wants a liposuction, and every time a day or two before it cancel. Continually mucks up your schedule, and you heard me or somebody talk about a cancellation policy that he actually signed. Well, here he does it again, and he forfeits his surgical fee. Well, being the lawyer he is, he wants his money back, and now files a complaint with the state board, and the board actually believes him and files a complaint against you, charging for services not rendered. How do you think that's going to turn out? You'll lose. And that's sad, but you're only permitted to have a scheduling and booking fee. Non-refundable, probably shouldn't be 100% of the surgical fee. Medicare allows to charge for a consultation if they don't show. But if you charge for surgery that's not done, you're really submitting a fraudulent bill for a procedure you never did. So I'd be careful. I've changed the language in the consents. Make sure yours follow along with this. The other issues that state boards look at is giving records. The patient owns the content of the record. You own the actual record. Patients come in and you delay and you don't want to do it. Many states, they can file a complaint and the state board will investigate you, and it really becomes an issue. I'm also hearing appropriateness of care issues, and that becomes a problem. So here's the disruptive patient, referred to you by your PCP, started reconstruction by another plastic surgeon, changed insurance, now no longer accepts the insurance, patient's angry, and here they are, and everything starts off on this angry, demanding patient. Well, sometimes it's tough. I've always made a rule. I'm always a little concerned about breast cancer patients in particular. Are they angry? Are they emotionally distraught? Is there a psychiatric issue? Are they falling through the cracks? I'll go out of my way to try and meet them, because a lot of patients support at home changes and they're really kind of screwed, and we may need to be someone who becomes and stays their champion. So I'd be cautious about that. Here's a new patient for reconstructive surgery again. I'm not filling out any information forms. I don't care about your financial agreement. I'm not going to sign it. The front office says, geez, these people are just impossible and difficult to deal with. You go in the room, the patient seems great. The boyfriend is obnoxious and belligerent. Who are you taking care of? I've tried to ask the boyfriend to leave the room. Not the spouse, but the boyfriend. Because now boyfriends change, and if the patient makes all these decisions based on the boyfriend and not really what she wants, you have an obligation to help take care of the patient. If that doesn't go, gee, I'm sorry, I'm not skilled enough to give you the care that you expect, and that becomes an issue. So decide whether they're anxious or frustrated. Can you calm them, or is it just, I'm not there? The dilemma is if you have an exclusive contract, and I've always recommended in an exclusive contract to have an out. Otherwise, now what do you do? So if I have somebody like the belligerent boyfriend, I shut it down, and I've done this for a long time. Can you afford me? Do you have something I can fix? You know, I have to like you, and you're just making that really hard. Sorry to have wasted your time. No charge for today, gone. I strongly recommend, if it's feasible to do that, don't begin. That first bad visit is often the best visit, and it goes downhill from there. So here you have Mary, who is an abdominal wall reconstruction composite. She said she stopped smoking 3 weeks before, never really did. You keep seeing her with the pack of cigarettes in her purse, and there's all. So now you're kind of stuck a little bit. You're going to operate on her. You have the date picked and all, and you figure, well, let me just make a more elaborate consent. Let me say that if you continue to smoke, you're going to not heal, you're going to have things fall apart, you'll get a recurrent problem, and you think, well, you're covering yourself because of that. Well, I don't think you are. I think what happens from doing that is you're actually setting yourself up, because you're the doc. You should have not treated the patient. You should have known by you making your more elaborate consent that you're now acknowledging that it's a more difficult patient and maybe your choice was not the most appropriate. You can't defer to the patient to pick a bad choice. It comes back to you again. So think that through a little bit. See people more than once. The more you have to have a very elaborate negative consent, the more it sets you up, and I'd be really, really concerned. I've told people who continue to smoke that the morning of surgery, I'm going to do a Cotinine test. If it's positive, I am canceling your surgery, I'm keeping your non-refundable amount, and I'm discharging you from my practice. If you don't care about you, I have to care about you, and I'm not going to be a party to you ruining what we're talking about. So if you're honest and you're still smoking, you need to let me know ahead of time so I can place your spot and maybe get you to a hypnotist or Chantix or someone else to help or change what's going on. The good example of some of these things is the Bridezilla mother. who now they're going through all the plans for this wedding. The wedding is 3 weeks away. The mother comes in now realizing, oh my God, I'm going to be in every single picture, smoking as the cigarette's hanging out of her mouth. You need to do a facelift. You need to do this. Well, I won't do a face on smokers. Maybe it's not the appropriate time to have everything that may happen in any procedure you choose with that short a window. So take a step back and evaluate it. What else can I do? Fillers, fat injections, something else to kind of meet a little bit in a very safe, protected way. So let me spend a minute on informed consent, because this is an issue in a lot of lawsuits. It's not an issue in reality, but it sets up how you're perceived in this system. You got to be really honest about revision rates, about compliance. How many of these have you done? And if you're new in practice, you may have done a lot in residency or fellowship, so it's not difficult to say I'm relying on my clinical experience and training. It's not only how long are you in practice, but be careful about how you expand this. If you tell a patient in advance that something might happen in the past, gee, you're really smart. Now, well, wait a minute, what did you do to reach this? So I've kind of covered this a little bit. Make sure you have enough time to personalize what's going on and interact on what expectations are from the patient. Otherwise, you're going to have lots of issues. So I would plan that there will be office staff changes. Create an office policy manual covering what may these triage people do. May they commit a patient to the practice? Be really cautious about refilling prescriptions or giving advice over the phone a year and a half, 2 years after someone's been seen and all of a sudden they call. They may have seen an attorney and the attorney says, I can't give you an answer before your statute of limitations. Call back, get any advice, and start your clock all over again. So be really careful. Evaluate appropriate procedure choices and clearly accept patients that you like. That's always a good thing. God, I saw this about the old cliche, there's no I in team. And in fact, I saw this and I thought, oh, how cute. Yes, there is. The I in team is hidden in the A-hole. And I'll let you evaluate that from there. There are tough times. Managed care is not a protection. Just because you have a contract that may cover some things, still seeing a lot of issues and a lot of lawsuits, even in staged procedures. Well, wait a minute, this is the first stage. I don't like how I look. It's the first stage. You're not supposed to be completed at this point. So I'd be really careful about matching procedure to expectations. Be real clear in this world of the demanding patient as to what works, and develop a good team in the office so everyone's on the same page and everybody is supported. I think that's one of the best ways to survive what's going on. Practice still fun. The paperwork and all of these restrictions, both federal, state, HIPAA, OSHA, are going to be really challenging today, and head up and look at things and be really proactive. Those in networks have a unique opportunity to move the dialogue and establish trends of care and treatment so the government won't do it. The bigger the group, the more you collect data, garbage in, garbage out. Good data will give a good idea as to what patterns can be cost effective and still good quality care. And I would really be careful not to change our ethics to adjust to the bureaucrat and their system. Good medicine is still good medicine. Patient safety and patient care still ought to come first. And the old other cliche that if you take care of people and you try to do empathetically and compassionately the best you can, you're going to be successful in practice and do well. Well, I tried to go through this as quick as possible. This could easily be a 2-day course. The Affordable Care Act could easily be a 3-4 hour. And I wanted to leave time to discuss or any specific questions, try not to talk about any cases that are affecting you directly, but the hypothetical works well. And if there's something I let go and didn't cover enough or didn't mention, now's a great time to either type it in the question area and I can address it from there. Oh, it can't be that clear to everybody. Or maybe it is. Hi, Deb.
The conference is no longer in listen-only mode.
Oh. Neil, hi, this is Deb. Can you hear me?
Yeah, I can. How are you?
I'm good. How are you?
I'm good. Thanks for putting up with this.
This is very good. Thank you. I have a question on before and after photos on websites. I'm now back in private practice after being in a large group, and I decided not to do the before and afters on my website, even though all the marketing people push to do that. And I guess my biggest concern is even with a consent, I think patients don't really understand the issues of it being on a website, that once it's out there on the internet, it's always there. We tell our kids that. We tell everybody that. Don't post the naked pictures. Don't do sexting. And yet we're putting up pictures on the website. And a patient knows that they're there, and they tell one friend, hey, look, my boobs are on that person's website. And then their friend clicks on it, copies it, sends it to somebody else, and it's there forever.
Forever. Well, the marketing people do push it. So the best suggestions are, if you are going to make a marketing decision to do that, the HIPAA consent is inadequate. There needs to be a commercial consent because you're benefiting from their property. And the commercial consent needs to be very specific about where it will be. A brag book, a website, a social media response, a book. How long can it be there? And the patient needs to, in writing, understand that and sign that. Next, the metadata of the before and after have to be scrubbed, so there's no patient identification involved. Yeah. And I think more importantly, it has to be a fair and adequate representation of your practice. So if it's your superstar result, are you implying a warranty that all your cases will look that way? I think that becomes an issue in this crazy expectation world we live in. And I think there are pictures that are okay, so let me give you another option. One might be to put a PowerPoint having your pictures with an explanation up on a website. And I like a little program called morpheasoftware.com. I think it's .com. It allows you to take a before and after and make a CGI or a bigger AVI file where it actually morphs, showing the before to and after, and it'll keep repeating. You can have an explanation. Breast pictures, what implant, high profile, not, what are the dimensions. None of that stuff is often included. And it can be more confusing to patients than not. So while I agree with you, I'm not going to win that argument because just about every marketing person tells you to put pictures up. And that becomes an issue. So do so with great caution. Make sure you have your consents there.
Yeah, didn't want to make appointments until they saw. I wouldn't.
One of the other questions that came up, how do you manage absolutely false reviews that are posted? Wow, I'm still getting a lot of these. And one, how do you know it's false? If it's absolutely false, then you ought to have the IP address from where it's posted, do a research on where it comes from. If it comes from a computer in a competitor's practice, I think that is an ethical violation. And I would keep the data and the IP address and file a complaint with whatever society you belong to. I wouldn't let that go. I wouldn't, even if I had a letter in agreement with a legal cease and desist to the other person filing it, I would still pursue it because that's going to be more rampant and it needs to be stopped. If it's patients, then I don't know what to tell you. If it's a false review, do what Grant Stevens does, and get your champions to come out, and for every one review, have maybe 15 saying how good their results were. Just be cautious not to solicit those. In some states, that's a violation if you solicit responses. But I'm hearing about more and more false reviews, whether it be from a competitor, a crazy prior patient who didn't get their expectations, doesn't have a lawsuit, and this is their way of getting back at you. If they make up stuff, look up in your state defamation per se, where states have issues where if you have sexual misconduct, criminal convictions, all of which are absolutely not true, you don't need to show damages. And many lawyers will take that possibly on contingency, and then you can sue the person as a result of that. It is what it is, and it's a sign of the times, but it's not going to go away unless there be some other controls to it. Tough question, and I wish I had a better answer to it. Choose your battles more carefully, and do you want to be consumed by trying to spend a lot of money on this when in fact it's a negative review, and so what?
Don't want to make you practice.
No, take that. Nothing wants me to make practice.
Any other comments? One of the other issues that comes up if it's a false review, not about results. Remember, you can't answer specifically from a HIPAA because you don't have a HIPAA approval. If I waited too long or parking's too expensive, be empathetic. I'm sorry about delays. Maybe call the office ahead of time. Leave a number so we can get back to you. Yeah, I'm sorry that there's a parking issue. We're trying, be empathetic. Sometimes the resolution of these negative reviews comes directly positively back to you, and it may be a good component. Well, I'm honored that I got asked to do this, and I appreciate the time from everybody. I'm so trying not to be the doom and gloom person, so hopefully there's some rays of sunshine out there somewhere that can help continue the wonderful, fun practice that we have. And thanks a lot.
Thank you. Please stand by.